Well, this is the story of an adventure. It's an incredible venture of the Global Tax Treaty Commentary that puts at disposal a unique instrument that will make every other method of tax research obsolete. And so what we're doing, we're building a huge work. A real universal commentary on all ideas about international taxation. And all those ideas are immediately linked to documentation that is backing up those ideas.
This is a very, very big project. It involves a large number of authors, reviewers, country experts and an editorial board. And the reason for that is that we wanted it to be global, we wanted it to be authoritative, and we wanted it to be comprehensive. It's also going to be electronic, which is not something you find for this kind of product to date, so that it can leverage off the power of the IBFD tax research platform. The IBFD, of course, is not the only publisher in the world, but in this area, it's probably the largest publisher, and it has the largest collection of quality materials. And all those materials you'll be able to get through the commentary. So when you look at a particular issue, you'll be able to find what the treaties, how they deal with that issue, what the cases say about the issue, what the books and the literature in the database say about that issue.
I'm very excited about this project because it completely changes the way in which we operate with tax treaties. If you work with tax treaties every day, you really can't do without this. Everyone is worried in collecting information from different sources and very afraid of missing something out. Well, with this work, you will just get it easily and you don't need to worry any longer. I have already used it and it has changed the way in which I work with tax treaties. I bet you will do the same.
That's one product which looks quite interesting.
Thanks very much, Rajesh. It's a great pleasure.
I'm hoping to use it sometime very soon.
It's a great pleasure to be back here in Mumbai. We have met 5 years ago, and I'm happy that Nishith Desai is hosting this webinar. And the topic that I have selected for my presentation is pretty much related to the concept, the core concept of the D2TC. So in other words, to give us an opportunity to use tax treaties and to do research on tax treaties in a way that is reliable and that takes into account the development, the constant developments. As we all know, there are important developments taking place right at this moment, and these developments affect the way in which we interpret tax treaties. So the title, The Evolving Interpretations of Tax Treaties, pretty much reflects the difficulties and the challenges of all those who operate in the field of tax treaties at this moment. Evolving because they are constantly changing, and interpretations because they are different in different parts of the world. So, indeed, what we try to do with the Global Tax Treaty Commentaries is to provide a tool that allows us to take into account what's happening in different parts of the world. And my presentation is in fact based on one of the chapters which are already available in the Global Tax Treaty Commentaries. The challenges are that the substance and form of international tax law are changing constantly. And for this reason also, I think that operating with digital instrument makes it easier to be constantly updated on the development. It's a kind of constant flow. It's a modus perpetuus, so there is a constant development. And I think that this constant development is something which we all have to take into account in order to give reliable advice and also reliable interpretation of treaties. My presentation is structured into 3 parts, and throughout my presentation I will be using the tax research platform of IBFD, and if any questions at the end would like to focus on specific issues which are included in my presentation, we can also perhaps try and at the end of my presentation to make an actual use of that with broadcasting, so that you see how it actually works. So the 3 points are basic points, and perhaps for some of you are already quite well known. So the first point is the interpretation of tax treaties and the function of Article 3, Paragraph 2 of the OECD Model Tax Convention. The second point is related to the value of the OECD commentaries in the interpretation of tax treaties. And the third one is the relevance of foreign court rulings in the interpretation of tax treaties. Throughout my presentation, I will try to take into account the positions of India and their implications, but also take into account the developments that are taking place in the framework of the BEPS project and the massive increase in the relevance of soft law that is currently developing at this moment. This is something pretty much important if we want to understand that it could be the source of uncertainty for business, for multinational enterprises, but also that soft law anticipates the moment in which it turns into proper interpretation of treaties, and therefore it's having an idea of how this is developing gives also an idea of the potential developments in the years to come in the interpretation of treaties. So it's something that we have to keep under control and we have to constantly monitor. So we are all familiar with the fact that tax treaties do not define all terms that they use. Some of them are the object of a specific definition. In most cases, this definition is contained in Article 3, Paragraph 1. But at the same time, we're also aware that a number of terms are used but not defined, and there are some gray zones, and the gray zones are the ones in which we do not find a definition, but we can find some useful elements for the interpretation of reconstructing an autonomous definition for tax treaties. And the issue is that in some cases we have those elements in the actual wording of the model by putting together different provisions of the model and trying to see how their interaction operates and whether we find some useful elements. In some other cases, those elements are not included in the model, but are included in the commentaries on the model. And there, of course, we start to have some difficulties because we need to understand the actual status and value of these commentaries. Several years ago, Richard VANN was chairing a panel at IFA Brussels in which we analyzed the legal status of the OECD commentaries and also took into account the foreign court decisions on tax treaties. And there was a very fragmented pattern that arose from there, which is basically that the value of commentaries and foreign court rulings is very different across the world. So the world of practice in the interpretation of treaties is rather different from what it appears theoretically if one looks at the OECD Model Tax Convention. Of course, this is even more fragmented and complex if we look at the global level and we understand that there are significant discrepancies across the world which go beyond the difference between OECD and non-OECD countries, or treaties following the UN Model Tax Convention or the OECD Model Tax Convention. So this is truly a big issue, and there are essentially three theories which are taken into account, which have been developed by literature and also which we find reflected in the wording of the judgments and also that we see across the world. One of these theory is that there should be a strong reliance on domestic law because this corresponds to the wording and meaning of Article 3, Paragraph 2 of the OECD Model Tax Convention, Another one is that we should go for an autonomous meaning, because in fact it is hardly ever possible to avoid the search for an autonomous meaning, and then there are some variations of theories which bridge between the two completely opposite theories. Now, I think that we cannot do a proper analysis of those theories without taking into account the actual wording of Article 3, Paragraph 2, as regards the application of the Convention at any time by a contracting state. Any term not defined therein shall, unless the context otherwise requires, have the meaning that it has at that time under the law of that state, for the purposes of the taxes to which the Convention applies, any meaning under the applicable tax laws of that state, prevailing over a meaning given to the term under other laws of that state. Now, of course, you know, the big difference between the two opposite theories and the value of the theory that tries to bridge between them, the big difference arises as to the meaning of the words unless the context otherwise require. When does the context otherwise require? That is something which is you know, object of speculation, but we have to understand also what the actual context is and whether and to what extent we can achieve some consensus in this respect. Now, what is the reason to refer to the context? Do we understand that without reference to the context, we would have a provision which would read, any term not defined therein shall have the meaning that it has under the law of that state for the purposes of the taxes to which the Convention applies, which would mean if there is no definition, then we automatically go into domestic law. However, the presence of the context makes it possible to try and go for an alternative solution. So if there hadn't been a reference to the unless the context otherwise requires, then we would automatically go no definition, we go to domestic law. So if there is you know, this reference, then we must understand that it must mean something. So, and if it must have a meaning, then we need to give a useful meaning to that. So in other words, we cannot think that we automatically go into domestic law whenever we don't have a definition. And here I'm trying to put forward also what I perceive to be the type of variation that I consider to be interesting, and that is we have to understand that if there is no definition, then we have to try and find some elements, and those elements are related to the context. What are those elements? Where do we get those elements? Those elements are, in my view, to be taken primarily from the same convention, so from the same treaty, because when we try to reconstruct the meaning of the convention, we have to take into account what a specific provision was included, was meant to regulate. So what the negotiators had in mind at the time that they concluded the treaty. Each tax treaty is a package deal, and therefore we have to understand, if possible, in the light of the preparatory works and all relevant elements, we have to understand what the negotiators had in mind. But what they had in mind does not necessarily have to regulate what has been included in the treaty. So sometimes we have in mind something, but then we accept something else, or we formulate it in a way that does not entirely reflect this. So the context should, in my view, heavily rely on the actual wording of the provisions included in the treaty, which doesn't mean only the ones that contain definition, but any other relevant element included in the treaty. So in other words, if we, for instance, want to try and find a definition on what should be income from employment and what we should regard as employment, we could also go as far as taking into account provisions such as the one of Article 3, Paragraph 1, letter H of the OECD Model Tax Convention, which refers to the meaning of the term business and which ends up in saying that it also includes other activities of an independent character. So from this, we get some useful element that by no means unemployment can refer to something which has an independent character, because that is something which is defined by a treaty provision, a different treaty provision, and in my view, that's one of the many examples that we could take from the treaty, the wording of the treaty. It's a definition related to a different provision, but which also affects potentially, or the framework within which we should be seeking for the context within which Article 15 operates in a given tax treaty. So this is just an example based on the wording of the Model Convention, assuming that the specific treaty provision will reflect this Model Convention. So, in other words, that means that it will not include an Article 14. Therefore, following the OECD Model Tax Convention as in its wording since 2000, we can bring additional elements which start to get more into the gray zone, because when we see elements which can be relevant to define the context, but which are not taken from the wording of the model, but from the wording of the commentaries, then we need to understand whether in fact they are truly relevant for the purpose of understanding the context. And here the answer depends on the value and the legal status of the OECD commentaries. Now, I think that one possible example that we can refer to is the one on beneficial ownership. Since we do not have a definition of beneficial ownership in the treaty, or at least for tax treaty purposes, then we know that if we look at the commentaries, then we find some relevant elements to understand what the treaty negotiators had in mind if they included a provision which makes reference, as in almost all the cases, to the beneficial ownership. Now, of course, this has to take into account that treaties can refer to beneficial ownership where the OECD model refers to beneficial ownership, or to put it somewhere else, like for instance the Australians do, and put it somewhere else in the provisions of Article 10, 11 and 12. So we can try to get some meaning or some useful element to define a term which is not defined in the treaty, or to define the context which is important for the purpose of determining whether or not we have to go into domestic law. But then again, that has a more limited value, also because in some cases, as we know, the legal status of the commentaries is very limited. So the important point is that we have to give a useful meaning to the reference of unless the context otherwise requires, and we have to take into account that had such provision or such wording or such words not been included, then we would automatically be able to go into domestic law in the absence of a definition. Now, somebody can say, okay, but if we are not allowed to let's say if we have to give a useful meaning to unless the context otherwise requires, the context can also require that you rely on domestic law. So that is clearly one point that we have to take into account. So in other words, the context can make it clear that you have to rely on domestic law. So the fact that we have to give a useful meaning to unless the context otherwise requires doesn't have to take us to the conclusion that we may never go to domestic law just because we want to give a useful meaning to the unless the context otherwise required. And I think, I have brought some examples, and those examples that you see in the slides are examples that we can easily find in the tax research platform of IBFD. I have made examples related to France. FR stands for France, and one of the reasons why I chose also France, or accepted to have France in this slide, is because in France the value of the commentaries, in particular for the judiciary, the commentaries on the OECD Model Tax Convention is very limited. France is one of the countries that acknowledges the role of interpretation or technical tools for interpretation, but could be considered to be a country which gives a very limited relevance to the OECD commentaries. The two examples are related to cases of recharacterization of income from debt claim as dividends, and in the absence, that's the position of the Conseil d'État in the case Gollet-Buchel France, this position indicated that since there was no definition of income from debt claims in the treaty, then you had to go into domestic tax law because there were no additional elements that could be found in the treaty. So from this perspective, the position eventually made it possible to go for this recharacterization of those interest payments on commercial credits, and therefore to determine that the article on interest would not apply. The second case is a case concerning the understanding of a case concerning dividend, and the fact that there was an advantage resulting from a non-arm's length transfer pricing deemed to be a distribution. Now, the situation that we have therefore is that in some cases, unless the context otherwise require, can lead us to go to domestic law if there are some elements that prove that domestic law is particularly important in this situation. But I want to put it this way, that I would only go to domestic law to the extent that we do not find any relevant element either in the treaty or in relations between countries that give that accept the relevance of the commentaries on the OECD Model Tax Convention, also no element available on the treaty. My point is that there should be no extreme interpretation, no zero interpretation, no zero possibility for autonomous interpretation of treaties, or no zero interpretation for domestic law. But I would rather say that every time that we rely on domestic law, we create a situation in which each country can interpret it in a different way, can interpret the provision in a different way. And of course, if a given term is to be interpreted differently, that creates a situation in which there could be some inconsistencies that could create some discrepancies and therefore could damage business. Now, of course, treaties are not perfect, and therefore we should not just try to make all our possible efforts to avoid inconsistent interpretation, but frankly speaking, right at the moment in which we are trying to go for consistent interpretations, then if we are to go into domestic law, then we should try to make it possible that there is this consistency. And John Avery Jones, in the chapter that we have included in the Global Tax Treaty commentaries, is showing that this consistency can also exist at the time that we have reliance on domestic law, in particular taking into account the obligations to give relief on the basis of the credit method and the provisions, the clauses and the paragraphs that are included in Article 23 of the OECD Model Tax Convention. So from this perspective, I would say that even when we rely on domestic law of one country, then we can have a way to bind the other contracting state. If one follows, in the case of the application of credit in particular, but also in additional cases, the theory which is reflected in the commentary and the characterization that is to be preferred in the cases of conflicts arising between domestic law. So here the issue arises as to whether this interpretation based on the commentaries of the OECD Model Convention has merits also beyond the sphere of relations between OECD countries. And of course, that is something which is even more in a gray zone than what we have admitted until now. So in other words, if it is not sure that in an OECD, in a relation between two OECD countries, there would be some consistency with what is indicated in the commentary. I made the example of France, but I could bring additional examples, such as, for instance, Italy. Then when we have relations with non-OECD countries, then one may wonder whether at all the OECD commentaries have a value. And here, of course, the issue shifts from the level of technically consistent interpretation to the level of, I would say, legitimacy of the OECD commentaries to influence treaty practice not involving OECD member states. Now, one easy way to address this would be, well, if a non-OECD member state accepted a provision which is in the OECD Model Tax Convention, then that state has implicitly accepted also the commentaries. And of course, this is a too simplistic way of addressing the problem, and it's in fact very far from the reality. Very far from the reality because, of course, a non-OECD member state has no reason to be bound by an interpretation or a technically correct interpretation on the of the OECD Model Tax Convention. Here I think it's, in the commentaries, here I think it's also interesting to consider the developments that have occurred over the past few years since the time that the OECD Model Convention and its commentaries were supplemented by the position of non-member countries. So we know that we have position of non-member countries on the model and also on the commentaries. So from this perspective, I also think that we need to wonder what has happened since we have those position included in the OECD model and its commentaries as an additional input. Now, we understand that the inclusion of those positions was something to achieve greater transparency. And in fact, when I was here 5 years ago in Mumbai to lecture on tax treaty, on several things, including tax treaty interpretations, when we got to talk about the differences existing on permanent establishment, then we started to find out a bunch of positions of India. I think in particular in 2008, India was quite, producing quite a number of additions to those positions. And indeed, it gave me the idea that I, not being used to operate with Indian treaties, could have a better understanding of the enormous differences that exist as to the boundaries of permanent establishment. So indeed, empirically, I could be a witness of the fact that if that is the function of the positions expressed by non-member countries of the OECD, they had achieved that goal. But still, the issue arises as to whether India would need to express its position in order not to be bound by the commentary. And here the answer is clearly no. So I can't accept the idea that a non-OECD member state has to be bound by the commentaries except in cases where it has specified that it has a different position. So from an OECD perspective, perhaps this is not correct, but I think that in terms of legitimacy, the OECD and its member states are free to go for for what they consider to be a technically correct interpretation, but they cannot oblige other countries to be bound by that interpretation. All that a non-OECD member state can be bound to accept is that if it has signed the wording of a treaty, that wording will bind that country. But how that country, which is not a member state of the OECD, interprets that treaty doesn't have to be bound by the interpretation in cases where it hasn't put a specific position. So I think, this is important also in terms of legitimacy, because the OECD Model Convention reflects international tax policy of a group of countries. And this international tax policy cannot be extended to other countries. Of course, this is my personal view, and I am also trying to bridge between positions that are typical of OECD countries and positions that are typical of non-OECD countries. Now, IBFD publication at this moment is also working on a book which is related to the role of BRICS in international taxation, and we have, this is a publication coming out next year, and we have several examples of how this is very problematic when it comes to interpret the treaties and the value of the commentaries. Now, of course, this takes us back to the place where we were, and the place where we were is related to the scope and function of Article 3, Paragraph 2 of the OECD Model Tax Convention. Here, when we work with the meaning context, we have to take into account also that we should consider the object and purpose of the model, but without forgetting the very special nature that we have in tax matters, the treaties, because at the same time we have a model convention which doesn't have a direct value, and then we have the actual treaties, which are what states sign. So I am about to start to mention something which has a binding value for the 114 countries that have signed it, but which doesn't bind India. And I'm sure that all those who are hearing me are aware of the fact that I am introducing some reference to the Vienna Convention on the Law of Treaties. And the reason for including a reference to the Vienna Convention on the Law of Treaties is not to speculate on a binding value that doesn't exist for states that haven't signed it, but rather to understand that at the very time in which we have a coordination of international taxation, and that we have a growing importance of soft law in determining what is the internationally accepted tax practice or what are the internationally accepted tax standards, even non-signatory states of a convention cannot completely ignore it. And certainly we do have relevant points here from the Vienna Convention on the Law of Treaties as to the interpretation of treaties, and in a few minutes I will make reference to Articles 31, 32, and perhaps something on Article 33, in order to understand how this affects the interpretation of tax treaties and whether it can, to some extent, prevent interpretations of tax treaties of one and the same tax treaty. Now, for the time being, I have to say that the Vienna Convention clearly endorses the view that we are to interpret the treaty in the light of its object and purpose, and I must say that also the developments on OECD Action Item 6, I'm sorry for the typo, it's not 16, don't get worried or don't think that this is a trick to draw your attention and to try to see whether you are in fact following. This is just a naive and simple typo. But sometimes when I'm lecturing, I do include some tricks, but in particular when I'm lecturing at LLM, LLMs, in order to try to see whether my students are indeed following. So, and usually it works because in some classes there is always somebody who's paying attention to what the teacher is saying. But now, I was just saying that the relevance of object and purpose and of the preambles is strengthened also in the OECD Action Item 6, which was one of the deliveries by the OECD BEPS project last month. So not just the object and purpose, but also the relevance of the preamble. And this is something that we are to take into account more than we have done until now, also because there is a general trend. So it's not because of the BEPS project, but because there is a general trend which reflects the importance of countering what many people call aggressive tax planning beyond abusive practices. So there is a general trend which in the world shows some kind of potential for accepted practice, and that is pretty much related to not just the avoidance of double taxation, not just the avoidance of abusive practices, but going in the direction of countering double non-taxation. And at present, this is just soft law, but we are to take into account soft law at the time that we interpret treaties. We cannot just ignore soft law. Soft law is not hard law, it's different, but at the same time, it is something which at some moment will turn to be hard law, but at the same time, it's the living law, and it is the way in which also the judiciary can consider the practice to be reflected. In some parts of the world, we have specific issues because the judiciary takes that into account and brings it also with significant relevance, and that is in the European Union, where sometimes the European Court of Justice makes reference to the internationally accepted tax practice, and it gives some special importance to that within a given judgment. Now, I think that this position allows us to reach some kind of remark on the first point of my presentation today, and that is that while understanding the meaning of Article 3, Paragraph 2 of the OECD Model Tax Conventions, we have to differentiate the value of the OECD Model Tax Convention between member states and in relations with third countries. In principle, there is some kind of common ground that we are to take into account, and that is that when a term is not defined, we cannot automatically go into domestic law, but we go to domestic law to the extent that the context allows us to do so. The context may require many things. It may require to go to domestic law, it may require not to go to domestic law, and in my view, it may also require to take into account what tax treaty negotiators had in mind at the time that they signed the treaty, and this can be, in my view, also the commentaries of the OECD, on the OECD Model Tax Convention, in particular between member states of the OECD. But then we have a slightly different pattern whenever we have reservations and observations. The slightly different pattern, I am talking here not about position of non-member states of the OECD, but I'm just talking about proper reservations and observations. When we have a reservation, we have to understand that the reservation is a reservation on the OECD model provision. It's therefore not to be regarded as a reservation in the proper meaning that it would have under international tax law. It's a reservation on the model, which means that if a country has a reservation and then includes in a bilateral treaty a provision which forgets about this reservation, what matters is what we have in the treaty and the wording in the treaty which was signed. It is a little bit more complex to determine the implications in the presence of an observation, because it's an observation on the commentary, and therefore we need to understand that there must be a value of this observation. So if a country put an observation on the model, it means that it made it clear for the other contracting state that it would not endorse a given interpretation of the treaty. So we cannot forget this when we try to determine the context. So the observations are particularly important from this perspective. Now, for the treaties with third countries, I think I have already said enough, and I want to move on to the following slide. So we have different commentaries, the OECD commentaries and the UN commentaries, and at the same time we have a number of treaties which have a fairly large group of common expressions. Sometimes we find ourselves in kind of hybrid situations. So in other words, we have in particular, in respect of Article 14 of the of treaties, some treaties don't include it, no longer include an Article 14, and that is something which follows the current version of the OECD Model Tax Convention. Some countries include bilateral treaties which follow the current version of the Model Tax Convention, but include an Article 14, and include also more specifically the version of the OECD Model Tax Convention which existed until it was deleted. So that is important. Of course, we expect that in Article 3, paragraph 1, letter H, there would be a key element to understand the difference or what the actual treaty negotiators had in mind. But at the same time, we can also have some provisions which are not patterned along the same model. So it's very common that if we find the 14 in a treaty, at this moment we find it patterned along the UN Model Tax Convention. These are some of the issues that one of the authors of the GTTC, who happens to be a respectable Indian colleague, D.P. Sengupta, is addressing in his chapter, because there are difficulties in making a consistent interpretation of treaties in this situation in which we have several models, we have several commentaries, we have one bilateral treaty which has to some extent some provisions which follow one model, some provisions which follow the other model, and therefore this is particularly important. It's one of the repercussions of the special nature, of what I call the special nature of tax treaties, because tax treaties are bilateral, but they are patterned along models, and we have to try and bridge the gap. Now, of course, treaties are often requiring to have a bilateral nature or a reciprocal element, but at the same time, we are also looking at a growing relevance of clauses that create some potential unbalance in the treaty obligation. And I see this as a case for the so-called subject to tax clauses, which try to achieve that we do not end up in double non-taxation, but which can interfere with the reciprocity element, even if someone can say, well, the reciprocity is achieved at the level of the treaty obligations. And at the same time, the additional element that I want to point out is that for tax treaties, we do not have a single judge, but we have separate judges in different countries. We have separate courts in different countries, the countries which have signed a treaty, but at the same time that the state, each state is at the same time the ally and the opponent, and therefore in many cases we end up in a situation in which the taxpayer loses or suffers the consequences of mismatches. My position is that at the time that we are making a major effort to counter double non-taxation or to push on the coordination of treaties, we should also take into account that the mismatches should be solved at the level of interpretation, not just when there is a problem of double non-taxation, but also when there is a problem of double taxation, which in some cases leads to mutual agreement procedures that take too long and yield nothing. Of course, I am aware of the tool of arbitration, and I, of course, hope that more and more treaties included and that we can achieve a better solution to those problems. Now, let's go to some reference to the Vienna Convention on the Law of Treaties, and the reference to those provisions, as you see, Article 31, 32, and 33, as I said, has value also for non-contracting states as expression of the treaty practice and the tools that inspire the interpretation of treaties by 114 countries. So, in Article 31 of the Vienna Convention, we do not just find reference to the interpretation in good faith, to the interpretation in the light of its object and purpose, but also to the ordinary meaning to be given to the terms of the treaty in their context. Now, the Vienna Convention on the Law of Treaties defines the context in Article 31.2 and includes some specific reference to agreements and instruments which were made between the parties in connection with the conclusion of the treaty, and or if it was done by one of them, which was accepted by the other one. So the question arises as to whether and to what extent this interpretation of the ordinary meaning in the context ordinary meaning of the terms of the treaty in their context has an immediate impact on the interpretation of the reference to the context in Article 3, paragraph 2. Now, from the wording of Article 31(1), we understand that there is one specific element, which is the ordinary meaning, and that there is a reference to the context, which clearly refers to a context in a treaty, so which can be that treaty or other treaties, which could be, for instance, protocols, and at the same time something which is instrument made by one or more parties, made in connection with the conclusion of the treaty and accepted by the other parties. So whether that instrument includes whether or not that includes domestic law, it's difficult to tell for all treaties, but certainly we cannot completely remove the relevance of domestic law, even through the gateway of the context under Article 3, paragraph 2. So from this perspective, I think that despite or beyond the differences that may exist in the interpretation, we cannot exclude the relevance of domestic law just because of an interpretation which would be closer to Article 31, paragraph 2 of the Vienna Convention on the Law of Treaties. But if we try to see the value of the commentaries under the Vienna Convention on the Law of Treaties, then one may wonder whether the commentaries could get in through Article 31(3) or through Article 32. If it gets in through through one door or the other, it will make an enormous difference, because Article 32 is either to confirm the meaning or to determine it when the interpretation according to Article 31 is manifestly absurd or leads to unreasonable results. Now, the example of beneficial ownership shows that it makes a lot of difference for us if we go for Article 31 or Article 32. And indeed, if we go for Article 32, then we achieve some results which in the field of tax treaties would be to some extent difficult to reconcile with the current practice of interpretation of treaties. And I think that to the extent that OECD member states have gone for drafting a commentary to explain the technical meaning of this of the commentaries, then that should be taken into account at the moment in which we give this term an ordinary meaning in the technical context. So that is the position that I would consider as most interesting. But then the issue arises as to how we would interpret the term in relations with non-OECD countries, in particular the ones which have signed or which have made accession to the Vienna Convention on the Law of Treaties. And there, I think that the substance cannot be changed to the extent that there is evidence of the fact that the ordinary meaning of a term has reflected the position of the OECD Model Convention. This is difficult because if a country is not a member state of the OECD, then we have to try and be consistent with the conclusions that we have reached before. So in other words, we have to understand truly whether the ordinary meaning in the context of that treaty reflects the ordinary meaning of that term in the context of the OECD Model Convention. So it is eventually leading to some kind of, weaker relevance. When we look at the statutes of the OECD commentary, we can refer to a number of judgments from some countries. Here I have brought some cases which we have in the tax research platform. So for instance, in a case of the Czech Republic Supreme Administrative Court, that court came to the conclusion that there was no evidence that of this relevance under Article 31. In particular, as you can see from our summary, don't worry, it's not in Czech, it's available in English. I don't speak Czech, and I understand that in India only few people can master that language. And in that court said that we cannot consider the commentary as an expression of any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions, and therefore we only give the commentaries a value under Article 32. And the case from Italy is a case, again, not in Italian. We have a summary also reflecting this thoroughly in English, related to the actual boundaries of the OECD model commentaries. And then, in particular, this judgment is related to the presence of an observation made by Italy in 2005, which says, regardless, and this judgment says, regardless of what the actual meaning can be of the commentaries, this is a case on VAT, but the relevance for interpretative purposes clearly goes into the general context of PE, also in tax treaties. Then the fact that there was an observation by Italy makes a difference. So this is also something quite interesting. And I have brought more cases which you may feel free to consult directly on our tax research platform. I have also noticed that in India there is a reliance on the commentaries, and that is quite interesting. Because the commentaries have a high persuasive value unless in conflict with domestic law, and you give commentaries a value also, the OECD commentary a value in this high persuasive value also if you're not a member state of the OECD, but of course you have your own right to your own interpretation, and there is also an additional element which you may take into account, and that is the relevance of the UN commentary. And for instance, in this case by the Delhi High Court of 2014, I understand that this has been particularly important to determine the interpretation of the terms through which in the definition of a permanent establishment. Now, quickly, I want to go through the position concerning the static and dynamic interpretation. Now, I have brought a list of cases from countries that support the static interpretation, and a list of countries that support the dynamic interpretation. And the idea is that commentaries change also after the treaty was signed. For a number of years, there has been a kind of increase in this technique to keep stability of the treaties. So there is this dichotomy, which you see reflected in this Canadian, South African, and Austrian case, and the following cases from the Netherlands, Australia, Spain, and France. I believe that all materials are made of this slide are available, and then you can find the summary and, in some cases, the full text in the IBFD tax research platform. There is this technique of changing commentaries more frequently and keeping treaties stable. This technique sometimes leads to consider that some changes to the commentaries are just the outcome of a clarification, but we are not too sure that this is always the case. Sometimes we have innovative changes disguised as clarifications. I think that this is what we should try to understand. If it is an innovative, if it is a change more than a clarification, it's not a matter of static versus dynamic interpretation. this is rather a matter of avoiding that changes to the commentary are affecting the interpretation of a model of a treaty which was signed before. So please, when you interpret the treaties, when you interpret the commentaries, try to understand whether you could see that new interpretation of the commentary also in the previous interpretation of the commentary. Of course, if it's a clarification, then you can be sure that it's already contained or it's already implicit or intrinsic in what was included in the previous version. But if that is not the case, then you should consider that there is no issue of static versus dynamic. There is rather an issue of a disguised change to the model put in the commentary in order to affect previously signed bilateral treaties. I'm not saying that the OECD is doing that on purpose. I'm just saying that sometimes there are some nuances between what is innovation and what is clarification. And of course, professors sometimes are trying to argue a lot on saying, oh, no, this is just a clarification. But still, I think that, the important point that arises here is that if we are facing a clarification, we have to understand what type of clarification we have. Let's say if a given wording of the commentary has several meanings, but only one of them, because of the later clarification, is regarded as the technically correct one, then that meaning is already included in the previous meanings. So from that perspective, we cannot say that that is innovating, that is clarifying, but then the issue is, how can we make sure that the other meanings are to be regarded as being irrelevant? We cannot say that the other meanings are regarded as being irrelevant in a country whose judiciary follows the static interpretation, but we have no problem in countries that follow the ambulatory interpretation. But still, I would say that the key issue is also to understand whether the treaty negotiators at the time of signing a treaty could have in mind an application of the treaty to that specific situation. If that is possible, then there should be no major obstacle to apply that interpretation or to make it prevail also in countries of static interpretation. And I think that this is the way in which I would address the end of this second point. Now let's go to the final point of my presentation, which is rather brief, and that is there is a growing reference in international in judgments on international tax treaties to decisions from other countries and from the courts of other countries. In some cases, one may say that it turns into some kind of fashionable or trend. Let's say, like quoting Prevo or Indo Food. How many millions of times have we seen this around the world, considering that the countries of the world are not millions? Well, frankly speaking, I see that there is, if I compare the situation as it is now and as it was at the time that Richard VANN chaired that session in Brussels of the IFA conference, I think that there is a clear growing trend. There is a growing trend to refer to foreign court rulings in the actual judgments on tax treaties. We have to differentiate, however, when it comes to determining the value, because in some cases they could be foreign court rulings on terms defined by a treaty. So, in other words, if we have a foreign court ruling on a term defined by a treaty, it can have a different value from a foreign court ruling of a term not defined by the treaty. Furthermore, we can have foreign court rulings on issues which are related to one specific treaty, so we can have the court of the other contracting state giving a definition of that specific treaty, or we can have a foreign court defining a treaty which looks like the treaty that we are interpreting, or both looking like the OECD Model Convention or not. So if there is a trend that we can record, and if there is a tradition of common law countries to refer to how other countries have interpreted, courts of other countries have interpreted a given treaty, then I think that if there is this, there is this trend in some countries and a growing trend in other countries, I think that for the future, this will even further increase. I don't want to be too optimistic about the BEPS project, but the way that I see the BEPS project impacting international taxation is also that for the purpose of understanding the consistency, or let's say avoiding hybrid mismatches or solving the problem related to that, we will have to see how other countries also interpret a given provision. So I see that there is a potential exponential growth of the relevance of decisions from other countries for the purpose of applying a given treaty provision, or for the purpose also of preventing double non-taxation. So here is some reference to some important decisions that you will find on our tax research platform from Canada, United Kingdom, Finland, and also of the European Union. And this is a trend, this is a slide, which is my final slide, which reflects the influence of foreign court decisions in the right-hand side, and which also takes into account the value of the commentaries, which, as you can see, is different across the world. I think that for the time being, this is all I wanted to say, and I would like to thank you very much for your attention, and I think we can start our question time. Back to you, Rajesh.
Sure. Thanks, Professor Pistone. I think let's take the questions first from, again, on the audio. Operator, are there any questions? Can you just check?
Certainly, sir. Anyone who wishes to ask a question may press star and 1 on your touchtone telephone. We have the first question from the line of Shreya Rao from Nishith. Desai. Please go ahead. Yeah, hello, Professor Pistone. That was a very interesting session. And I think I'd like to pick up on a point that you made right in the beginning about the weight that non-OECD countries should place on the article on undefined terms and OECD commentary. And I think my question relates to what has been happening in India over the last few years, which is that, unlike some OECD non-members, like I understand Indonesia and China have expressly stated that they will not really be looking at the OECD commentary. But India, on the other hand, has several court judgments which have repeatedly reiterated the fact that it would have very strong persuasive value. So what we are left with today is that courts have sometimes appreciated the persuasive value of the OECD commentary, and there are also some cases where they've disregarded it entirely. And I think this boils down to the term context, which has been used in Article 3. And I was wondering how you see this term context being looked at in the context of the developing country experience, and how you see the undefined article provision evolving in the context of what's happening on the international tax scene today between developing and developed countries, and the positions that the BRIC countries are taking on undefined terms.
Thanks very much for your question, and also for breaking the ice. Eventually this is very much appreciated, and I think I can just reward your question by saying something which I know it's included in this IBFD book, which has not yet been published. So the trend that we see is that it truly depends on what kind of provision we have. So there is a strong friction which arises as to the value of some protection of taxation at source. So some countries, for instance, India, have let's say, trends to lower the threshold of permanent establishment, to put it with a kind word, which goes in a direction which is completely different from the strong persuasive value that they accept at the same time. And some other countries of the BRICS take an interpretation which completely ignores the substance of the commentaries, and or that achieves some kind of solution which doesn't take into account the commentaries other than in exceptional situations. So when you plead before Russian courts, since you were specifically reflecting to the BRICS, and I want to give you some premiere of what will be soon published by IBFD in 2015, when you plead before Russian courts, then you are likely to see that even if Russian treaties look like OECD treaties, courts hardly ever use reference to the commentaries, or they are formally there, but you don't use them. You don't use those treaties that much. And then Brazil has some positions which are to some extent different because of one important point of many Brazilian treaties, which is the right of Brazil to remain the master of international tax policy decisions. So it means that in some cases Brazil succeeds in including tax-sparing provisions to protect that right, but also in cases in which it doesn't achieve that, it achieves that result through, I should say, alternative paths, which can go as far as bringing under Article 21 something which would not be regarded as going under other provisions, and making 21 competing with Article 7. Please take into account that in Portuguese and in the treaties there is a different word which refers to income, and profits are using clearly a word which corresponds to profits, which is lucros, but that the word income is regarded as applying under Article 21, when all other provisions which refer to income, therefore not the one that refers to profits, are not applicable. So the interesting point is that there is a reaction that not only ignores or gives a limited value to the commentary, but that finds alternative ways to avoid getting into the interpretation based on commentaries. Now, frankly speaking, this whole problem is that non-OECD countries shouldn't interpret their tax treaties in the way in which OECD countries do. So I am not too sure that the correct way forward is to say that the commentaries should have, of the OECD, should have a strong persuasive value. They do have a strong persuasive value for OECD countries, but they should not necessarily have that value. And what I find rather difficult to accept is the legal uncertainty that arises in some non-OECD countries that on the one hand say that the OECD commentaries have a strong persuasive value, and at the same time they disregard them entirely. This is sometimes difficult to understand, but it's difficult to predict. When you have to advise your client, then you have to try and map what provisions of the OECD commentaries are highly persuasive and what aren't. But if some provisions are highly persuasive, they are not highly persuasive, in my view, because the OECD commentary is highly persuasive. But it's because the courts of this non-OECD country consider them to be persuasive, consider the arguments to be persuasive. So I would say, to bring this to a final point, that the value is in fact zero, and it's just the country that considers the arguments to have value and merits.
Sure, no, that's very helpful. And I think at least as far as India is concerned, the general position that all of us base our advice on is that the OECD commentary would have strong persuasive value. And I guess you're correct that at least in the situations where the OECD commentary isn't paid as much attention to, and we've had a couple of unfortunate cases on that front, which I think some of my colleagues will have questions on, it would probably just be a case of the argument failing rather than the commentary itself failing to have persuasive value.
Thanks.
Sure. Are there any other questions?
So no more questions in the queue.
Yeah, okay.
I have a very brief question.
One question from Mumbai. I think you need a microphone, otherwise
Or you need a speaker.
the colleagues will not hear us.
Yeah, my question was in relation with your comment that foreign courts have a lower value in the interpretation of defined terms and a greater value in the interpretation of undefined terms, if I understood you correct.
I'm not sure that this is what I said.
Okay. I think.
Can I repeat? Yeah.
Yeah, I think maybe I can paraphrase what I thought you said, which is
Yeah.
a bit different.
Please go ahead.
Is that when you've got a defined term, by definition, it's not undefined, and therefore it's an autonomous, like in autonomous interpretation. Whereas if it's an undefined term, then they may just be, without saying so, applying Article 3.2 and picking up the domestic meaning.
Yeah.
Which, and I think that's what.
Thanks very much. This is exactly what I meant.
Deriving from this thought,
Which is not what you said.
deriving from this thought, can it also be said that the word unless the expression unless the context otherwise requires is more relevant in terms of Article 3.2 and less relevant in terms of Article 3.1, because the same expression is also used in 3.1. And further from that, wouldn't it amount to almost nothing that the same expression should, you mentioned at one point of time that an expression has been used and it must have a meaning. But if the same expression has been used twice in the same article, shouldn't it have the same weight? And if one is to say that Article 3.1, it barely has any meaning to have unless the context otherwise requires, what meaning should it have for the purposes of Article 3.2? Given the fact that we know that historically it's been inspired by the 1945 US-UK tax treaty, which just used the common law practice of adding unless the context otherwise requires to absolutely everything.
Now, even if the word is used in 3.1 and 3.2, I am not sure that it has the same implications. I know that this will make you laugh perhaps, but the same word in a different context can have a different meaning. And I see some boundaries to use it to what can, unless the context otherwise require, mean under 3.1. And the boundaries is that I really don't see how we can get into domestic law. It's very hard for me to see how we can go into domestic law if we have a definition, whereas under 3.2 I see that we can go into domestic law. So that is perhaps my answer, is that even if it's the same wording, it doesn't have to have necessarily the same meaning because it's in a different context.
So the context requires a different interpretation of the word context in the context of 3.1 than in the context of 3.2.
Yes, that would be my spontaneous reaction. I know we have been using the word context a number of times, and then there may be people saying, eventually, why don't we get rid of all those contexts which were put there just for unknown reasons?
Thank you.
Sure. Thanks for speaking up in the microphone so that our colleagues from other parts of India can exactly hear your question.
Exactly. So, Professor, my question is with regard to the point on reservations to the OECD model that you were talking about, right? So, from an Indian perspective at least, we have quite a few aggressive reservations which have been put in the OECD model. And
I have a problem. India is not a member state of the OECD, so I have a basic problem I can't hear this too much, so please talk about positions of non-member states, because
of course.
A reservation is a reservation, right, so I would have a different view, so please, you refer to India.
Okay, so India's position on the OECD model on certain articles especially, has been specifically aggressive. Something like, partnership entities not being given treaty benefits, right? So coming from an Indo-food perspective, at least, shouldn't you be looking at, you know, an international fiscal meaning? So if an Indian court is to look at this provision, what do you think, in the sense that should the position of the country be given prominence, or the internationally accepted interpretation be given prominence?
Yeah, I think that each country has the right to determine its international tax policy, not just Brazil. So from this perspective, I think that courts of a country have to take into account that it is for the legislator of a country to determine what its international tax policy should look like, rather than just following the trends. Because the trends are dominated by some countries, and there may be positions of a given country which do not reflect the position of the entire world and still are positions of that country. So for me, this is an important point. I like, as I said, for the sake of transparency, I like the idea that India makes clear with a few reservations, as you call them, or positions of a non-member state, makes its international tax policy clear. Of course, you know, the clarity should also be as to the interpretation, as the question from your colleague pointed out, that is missing sometimes, but perhaps we can get that clarity by looking at the arguments rather than looking at the commentaries. But at the same time, I don't think that if a change has to be made, it has to be made at the level of interpretation. It is rather the lawmaking body that should change the boundaries of your international tax policy. This is a transparent way to do that. It doesn't mean that I'm against, you know, an interpretation that takes into account the internationally accepted tax practice, but it shouldn't be the leading force. Yeah.
Thanks.
I think a couple of follow-up questions, and this sort of feeds into the dynamics of the different spheres. The legislature, you have the judiciary, you have the executive. Technically, the reservation which Sriram is talking about was made by the executive, it was not made by the legislature, and that's been recognized by Indian courts to say that, well, it's the executive, too bad, I don't care whether they made a reservation or not, because it's the legislature which has the right. Legislature had actually technically entered into the treaty, so I have to give effect to that. And it's how the judiciary then determines the interpretation as far as what the legislature has essentially entered into. The other thing was, one of the points that you made was that when a non-OECD member country sort of enters into a treaty with the OECD member country, that you don't necessarily have to go back and rely on the model, the OECD commentary. And I think one of the issues that I have is that when ultimately the treaty is nothing but a contractual agreement which two states have entered into. It may not be two individuals, but it's two states. And to that extent, there has to be a meeting of minds as far as what have they really contracted into. A non-OECD member country, when it enters into a treaty with an OECD member country, it knows specifically that what the views of the OECD member country are, because the OECD member country is sort of looking at the OECD model commentary and sort of saying that, well, when we are saying, let's say Article 10 means this is what we think it is. So therefore, even if it's a non-OECD member country, the moment that they enter into a contract with the OECD member country, you automatically are agreeing to a certain interpretation, otherwise I'd be looking at a change in language. So you saying that I have to completely discount the OECD model commentary when it comes to non-OECD country, how do you sort of reconcile that with the whole idea of a contract being a meeting of minds?
Yeah, thanks for your question. For me, it's hard to say that the non-OECD country automatically agrees with the OECD country interpretation. And frankly speaking, I want to get back to the example that we've been using on and on about permanent establishments. So the outcome of this is that one country, says, yeah, okay, we agree on the clause on permanent establishment. Perhaps we make some changes. The construction fee, we just do it in a different way or other things. But then who pays the price is the taxpayer. So the lack of clarity is there because the non-OECD country, could be meant to accept the deal. And eventually, what we find out is that at the level of interpretation, this is just a dream. And this is simply not corresponding to the truth, because the country, the courts of a country will not accept that. So I am saying that if they accept to use the concept of permanent establishment, the non-OECD countries must not necessarily accept. So the difficulty that I have with you is about the automatic extension of the relevance of the OECD Model Convention. I think the arguments are what matters, and we have to clarify whether those arguments fit within the international tax policy of a given country. It is not just because we accept the concept of permanent establishment that we interpret it in this way. Sorry to make the example of permanent establishment, but that's a striking example of where in India we have big differences. This is why when I was asking Richard for his vision of the future, of where we're going, I had this dream, and I keep having the dream that we go towards some kind of consistent standards, because to the extent that the OECD truly goes for a dialogue with non-OECD countries, then we can build up what I call multilateralism. The substance of multilateralism can truly be legitimate at the time that several countries contribute to determine the standards of the rule. I see this as a growing trend, because for fiscal transparency, a bunch of countries dictated the rules which are now being applied by all other countries. And with the BEPS, we are seeing that the number of countries being growing to 44, and perhaps we can see a further growth. So I really think that perhaps a difference that you and I have is in the automatic acceptance of the standards. They only accept the concept, but not the interpretation. And the interpretation and the arguments are what matters, and you have to, in my view, to see whether there is a consistency with the international tax policy of a country. And then, of course, I really think that judges, also in this country, try to understand why some countries sign some treaties, some clauses, and also what the standards or the interest of this country as reflected in the wording of the clauses are.
And this sort of takes me to the next point. And one of the things, at least India has, which a lot of other countries may not necessarily have, is that they put the treaty on par with domestic law. So effectively, in all senses of the term, it is as if it's a separate set of law which the legislature has decided to enact. Because that's the
Are you referring to monism and dualism, or to something more specific?
No, so specifically what the Constitution today provides for is that a treaty, any treaty which India has effectively entered into, has to be given effect to. It is on par with any law which the legislature has passed. So once you go down that path, so you no longer have to go into the international tax policy or the country having to frame its own international tax policy. Because what you have effectively done is, by entering into the treaty, you have framed your policy. Because that's effectively what you have said, that this is what is going to be the provision of law. And that's where again the disconnect arises, because I think what you are looking at is to say that the country should still have the independence to determine the meaning of what it has really entered into.
Yeah.
Whereas what I'm saying, that's really what you're saying. Whereas what I think,
and do it in a transparent way.
Do it in a transparent way. Whereas what I'm saying, that the moment you have entered into it, you have already determined a particular meaning, because, well, otherwise you wouldn't have entered into it.
But let's judge what has happened on permanent establishment. So what we understand is that the broad lines perhaps have been set, but then eventually, when we move from theory to practice, the kind of problem that you find with your clients, then are arising from the fact that there is an acceptance of, let's say, the box, but what's within the box, then it's something which is the predict. So this leads to legal uncertainty.
And which is that's for the court.
And then the judiciary is in fact determining something which is making the law. Yeah. Clearly you have to understand that I come from a civil law country, and I cannot deny, but we have a common law country from the other side, so we are balanced, and you are India, so you belong to that tradition. But for me it's rather difficult to accept this, and it's also at the world level and the balance that we have right now, because some countries pursue some interest, and then I don't think it's fair and legitimate to impose those lines to the other countries, to the rest of the world. I see this as a rather colonialistic approach, and I am not saying that the OECD is having a colonialistic approach. The OECD has been doing a tremendous job to move towards coordination of international taxation. And I am particularly supportive of BEPS because this is enhancing. We can see that there is a tax governance of the world, and that it's a growing number of countries that does that. What I find difficult to accept is a sort of patchwork approach where, you know, let's say case by case basis, of course courts have to interpret the law, but making the law for a civil lawyer is a little bit difficult to accept. But, you know, I don't want to hide my nature. I'm a civil lawyer, certainly. Thanks, Rajesh.
Sure. Any other questions? I think that was quite an interesting session with multiple different viewpoints. But I think with that, I think we'll draw to a close. And we are right on dot. It's exactly 5:30. Thank you, Professor Pistone. Thank you, Professor VANN, for joining us. And all of this will get recorded, get uploaded on our website. So hopefully a lot more people will have access to it.
We get to edit it.
We will send it to you. You can ensure that you're happy with how you look.
And thanks very much also to those who have been following our talk at a distance. And thanks for the questions.